Oh yeah.
Katie Parker and Allison Williams and I are talking about chapters 11 and 13, which focus on the legal end of things in terms of child abuse. And the first chapter that we're going to go over is chapter 11, which sort of gives a first a more broad look and then a detailed look at the legal system and how that works in terms of child abuse cases. So the way that the U.S. court system is set up is really not set up to meet the needs of children. The way that we use the courts within the U.S. is an adversarial system, so it has pitting one side against another, and it would be a lot more beneficial if this system was set up as an inquisitorial system, so that judges were sort of gathering evidence and trying to figure out the truth from that, rather than having one lawyer against another lawyer and case by case basis, because that really is hard for children in terms of the way that they interact within the court system. It's already like a really scary system for them, and so putting them there is like very frightening and oftentimes kind of muddles up what the truth of the matter is. So being aggressively challenged by an adult is really overwhelming when you're a child, and putting them in that situation often kind of like messes up what the truth of everything is. So there are a few ways that systematically we're trying to combat that and make it easier for children. There's court prep groups that are designed by the National Children's Advocacy Center that bring children that are involved in child abuse cases into the courts in small group sessions before their trial is held. And they take place in about 6 different group sessions, and they're led by various professionals. And they take them into the courts, and they give them sort of a variety of things to help them make them feel more comfortable. So they give them information sessions telling them about how the courts function, what's going to happen when they're on trial, etc. They also help play some like role-playing games that make kids feel more comfortable, and they take them on tours, because not only is like the actual act of going on trial very scary for kids, it's the building itself, like the judges and all the sort of way that that's all built up for kids is not something they're familiar with. It's something that they maybe see on TV or see as being very sort of scary and adult. And so making them feel comfortable in that environment is one way that programs are helping kids to feel more comfortable in these like already super scary and super traumatizing situations. There's also similar programs, like in Canada, they have one that's called it's run by the Child Victim and Witness program, and it's similar, but it's more individually focused rather than as a group. So professionals will meet with individual families and individual children to help walk them through the process, whereas the ones in the U.S. are um, kids are in groups, so they have sort of like friends set up, or like there's a social aspect to it that this other one in Canada doesn't have. And so while this is a pretty problematic system, there are ways that we're sort of combating it and trying to figure out how kids can be more comfortable in the courtroom and make this already really traumatizing experience for them a little less scary. But there's still a lot of work that needs to be done there. And then Katie's going to talk a little bit about specifically what kinds of cases these students find themselves in, or these children find themselves in.
Great, thanks, Natalie. And Katie, Dara, and Todd, feel free to chime in with any questions as we go along. If everyone goes to the Google Drive tab and opens up that graphic organizer document, you can sort of follow along as I talk. I'm just going to talk us through sort of the different types of courts where allegations of child abuse might be heard. And I'm pretty much following along in this document, so feel free to take a look. So the first type of court where allegations of child abuse come is a juvenile court. And the types of cases that happen in a juvenile court are 3 types. The first is juvenile delinquency cases. So that's where children commit crimes that would be crimes if they were committed by adults, but they're not necessarily considered crimes. So that's not really relevant to child abuse, but it might be an experience that our students are having. The second is status offenses, and those are things like drinking underage or smoking underage, things that would not be crimes if adults did them, but that are crimes if children do them. And then the third is the one that's relevant to child abuse or neglect, and it's a type of case called dependency case. And in that kind of case, the court is deciding if the current guardians of a child are meeting the welfare needs of that child or not. So the charges in that kind of case are pressed by CPS or initiated by CPS. And the court's role in that kind of case is to decide where the child should be placed, if it's in the current living situation or if it's in a different living situation. They also come up with a treatment plan, which might be like certain steps that the guardians of that child should take to meet the welfare needs of that child. And then another decision is the visitation situation for that child with their guardians or parents or caretaker. And I guess I'll get to that in a minute. So the experience of the child in that situation might be that they're removed from their home. They might live with relatives or the state, and the parents might be on the treatment plan. And then some examples of the treatment plan are like parenting classes, drug or alcohol treatment, money for childcare, securing employment, or finding a place to raise a child. It's different than the current situation. So this kind of case has a really strict timeline. There are the initial charges, and then there has to be a hearing in about 6 months. And then if need be, it's reviewed again in 12 to 18 months to see what kind of progress the caretaker is making on the plan. And then in this kind of case, there are actually like relaxed evidentiary requirements. Sometimes what a child says to an adult can be allowed as evidence directly, whereas in another type of case it wouldn't. And then the note about original goals is that like this court was set up originally with the intention to like treat or rehabilitate children, but they actually ended up being guaranteed fewer rights because different things were more relaxed. So it's actually ended up like having stricter sentences for some children. This is more the delinquency part than the child abuse part, but I just thought it was interesting in terms of our students' experiences, that sometimes that's the way it used to be, but now I think they are getting better at giving children more rights in delinquency type cases. So those are the main ideas for the juvenile court. And if we slide over to the domestic relations court, that's another type of court where allegations of child abuse or neglect might be heard. So the types of cases that the domestic relations court hears are divorce cases, child custody cases, and child support cases. So in this case, charges aren't pressed by CPS, rather they're pressed by a parent or I think another family member or person responsible for the child. And then one of the interesting things about this case is that it's not like the state through CPS that is coming up with evidence, but it's rather the person that's pressing the charges, like the individual person that's pressing the charges, that has to come up with the evidence. So in this case, the decisions by the court include who has custody of the child, what the visitation plan will be, and it said that this is made in the best interest of the child, whatever those decisions are. So for the experience of the child in this situation, they might actually undergo several different psychological evaluations, either at the parent's request or at the judge's request. So they might have like multiple rounds of those. So that could be, I don't know, just one part of the experience. And then they may not have an attorney of their own. They may also be asked to testify in the presence of both parents to say who they prefer to live with or to like speak to their experience of being with their parents or caretakers. And then another important thing is that in terms of the experience of the kid is that the judge might not have any training in child development. So speaking to what Natalie was sharing with us, that it can be a pretty like re-traumatizing or traumatic experience in itself to be interrogated by a judge in this case. And then some other notes. It's a really small percentage of custody cases, only 6 to 20%, that are actually decided by the court. Usually things are decided by the individual people in the child's life, and it doesn't go to court, but it's still 6 to 20% that go. The court has little enforcement power, so once a decision is once something is decided, they actually can't really enforce that it's happening. And if somebody's violating the terms, then they might be held in contempt of court. But as soon as they stop the violation, they're no longer held in contempt of court. So there's not really any teeth to what court's decisions are in this type of case. Is this making sense so far?
Yes.
Mm-hmm.
Okay. The third type of court is criminal courts. And the types of cases that come to that court are like severe cases of physical abuse. So very severe, like permanent harm or death. Also, sexual abuse is sometimes considered there. That's a more recent phenomenon. And like they're considered in criminal court, that type of case. And then also cases of severe neglect that have resulted in permanent harm or death. The people bringing forth charges in this case are CPS or the police. And sometimes they can have conflicting interests because the police is trying to prosecute a crime and charge somebody, like find somebody guilty, and CPS is trying to keep families together, like as one of their primary goals and principles. So those are sometimes contradictory. So in this court, the decision can be felony or misdemeanor, ranging from jail time to the death penalty. The experience of the child in this type of case, there's some accommodation sometimes for children who testify, but a lot of times those types of accommodations have led to a mistrial because the defendant's constitutional rights are sort of in a gray zone at that point. So there's it's unclear whether that, I don't know, it's just conflicting things. But to try to protect the child in this case sometimes leads to a mistrial. And then another part of the experience of the child is that they might feel responsible for their family member going to jail. And it can also be re-traumatizing if a person, this is specifically if a person pleads guilty to a lesser version of the charges, which often happens, that there will be some kind of pleading guilty to a lesser version, and that can be hard for some survivors. And then some other notes, the vast majority of these cases don't make it to criminal court. And again, due process for the defendant is a part of this, and so that means that things are a lot more rigid and strict in terms of what kind of evidence is admissible. And it's the highest burden of proof, so there has to be a significant amount of evidence against the defendant for it to go through. And then there are a lot of critiques. One is that it doesn't actually address the underlying cause of the abuse or neglect, and it can divide families. It can be traumatic for the child, and the child can feel a lot of guilt around this happening to a family member, even if that family member has been an abuser. And then arguments for, prosecuting child abuse and neglect in criminal court is that it makes abuse and neglect a real crime, and it can protect future victims if somebody that's committed these crimes is found guilty. So that's some about criminal courts. And then the last type of court is a civil court. And the types of cases that come forward in this are abuse. When a child has experienced abuse, they can then, as an adult, be pressing civil charges against against the perpetrator. So again, the charges are pressed by an adult child, which, does that make sense? Like somebody who's now over 18 who was abused or neglected as a child,
right,
when they were under 18. Or they can also, if the person is still under 18, when the charges are brought forward, it can be an adult on their behalf that's pressing civil charges. So the types of things that the court can do in this case is to enact monetary penalties against the perpetrator, and think about the experience of the child. Again, they can be forced to testify. And then a few other notes. Oftentimes, the only way that an adult survivor who was abused as a child can bring something against the perpetrator is through this avenue. And then in this type of case, there are fewer rights that are guaranteed to the defendant. They're not actually guaranteed an attorney, which I thought was super interesting. They have to sort of present their own case. And then the standard of proof is lower. There aren't as strict of evidentiary procedures. And we've talked about this in class. Some of the possible defendants in this type of case are the perpetrator themselves, the state, if the state was an abuser, like a foster care situation, I think, and then like a non-abusive parent, if they're not protecting a child that they know is being abused, they can have these types of cases brought against them. And then, as we talked about, like teachers and other professionals that fail to report abuse. So that's a relevant piece for us, obviously. And then my last point is that a lot of times, if people are living in poverty, they can't be sued for money. So that's one, I guess, important part of this, is that it's really like has more teeth for people that have money that can be given to courts. So those are given to the survivors. Those are the 4 types of courts. I think that's the main information for me for now. Are there any questions? I have to turn my microphone off for a second, but I'll be back and you all can continue.
Okay, thank you, Katie. So we just, to sort of wrap that up, Katie touched on how sort of complex this issue is, and how obviously there is a need for the government to have a role in protecting children, but she used the word gray area a lot, and I think that's a really great way of putting it, because it's not always black and white. And while they're trying to protect kids, there's a lot of opportunity to sort of like reopen wounds and re-traumatize kids, especially in terms of the juvenile and criminal courts, and really being careful that kids aren't being punished or being sort of like re-injured in this process while we're trying to protect them. And as educators, that's something it's really important for us to be aware of all the nuances of this, that some of our students may and will be going through this experience, and it's important for us to understand everything that goes along with that, and how sort of, again, like re-traumatizing that can be, and just the psychological effects of that. And additionally, she touched a little bit on this at the very end, but I think that it's really important for us to reiterate the role of the civil courts, and for us as teachers, the implications that can have. That if, as we talked about in our Child Abuse Day with Steve, how we are mandatory responders or reporters, excuse me, and it's essential for us to report things when we see them, and beyond just like the moral and ethical implications of that, there's also legal ones, and the fact that this could come back later on if a child doesn't have abuse that's reported that we see, they could come back and press legal action on us as teachers and educators later on. So again, just sort of underlying our role within this, and both as reporters when we see this happening, and also as a support system for students that we see going through this obviously very difficult process. And then Allison is going to talk to us a little bit about Chapter 13 and the preventative measures that we can take in terms of keeping child abuse out of our classrooms.
Mm-hmm. Hello, everybody. Also, like Katie said, chime in or interrupt me if you have a question. Like Natalie said, I'm going to be talking about prevention of child maltreatment, and right off the bat, I'll say that as a country, we aren't really succeeding. We have a lot of room to grow in this area, as we know, because child abuse and neglect, maltreatment is significantly, our numbers are really high. So just start off by saying that we have a lot of room to grow. I'm going to talk about just kind of a brief overview of programs that we have in place right now, and give you some examples of them, what works and maybe what hasn't worked for us. So when you think about prevention programs, we are focusing generally on parents, right? It makes sense. It's thought that by improving parents' parental skills, increasing their knowledge about students, or their children's appropriate developmental stages and behavioral expectations, offering them support like counseling, individual counseling, community counseling. It's thought that if we have those in place, that we'll be more likely to prevent child maltreatment. A couple of brief examples of parent-targeted prevention programs are things like home visitation programs, and then, like I said, community support groups or partner support groups. Programs that also target specific populations of people, like maybe young teenage mothers who are single. It's just important to note that most of our programs are available for people who kind of recognize that they need more support, and we have less programs that are targeted for people that maybe aren't really realizing that what they are doing is considered child abuse or child neglect. So it seems like we aren't doing that great of a job of preventing because we're not able to get services to the people that need them the most. We can think about child maltreatment as a public health issue. In the last 20 or 30 years, it's become considered a public health issue because accidental or injury, accidental or intentional, is the leading cause of death for children in the United States. And child maltreatment is also considered a public health issue because there's a wide range of health issues that can arise if you're a victim of child abuse. If you are a victim of child abuse or maltreatment, you are at risk, higher risk than other folks for leading causes of death among adults. So that includes heart disease, cancer, alcoholism, and suicide. So it affects us, as we know, across the ages as our life goes on. And if you're a victim of that, it affects you as you grow older. So there's two approaches to preventing child maltreatment. There's primary and secondary, and primary approaches are programs that target the general population, and that would be things like public service campaigns, like billboards and pamphlets, those kinds of things. And some people, I think they're not held in the highest regard. Many people don't think they're effective, but the chapter said that at times these really wide media campaigns can be effective. For example, in the 70s, when people started, 70s and 80s, when people started talking about child abuse or child maltreatment as an issue that needed to be talked about, they launched a big public awareness campaign and teaching people how to report abuse and signs of abuse. And child abuse reports rose from 100,000 in 1976 to over 1 million in the early 80s. So they can be effective. Another primary approach, primary program, is parent education campaigns, and those are open to anybody who wants to use them. And they can be integrated through the school system or the medical settings. An example of that is something called the Detroit Family Project, and with that program, parent facilitators have a cart that they take through waiting rooms, and it has pamphlets and toys and snacks, and they just initiate kind of informal discussions with parents in the waiting room around a variety of issues around parenting, and they reach 25,000 parents annually. So that's one approach. One prevention approach that just kind of reaches the general population. And so, like I said, most child maltreatment programs target the parents, and that is true for child abuse and child neglect, but for sexual abuse, prevention programs generally target the children, and there's usually components that are parent ed around sexual abuse, but it's thought that the most effective way to prevent child abuse is to educate children. The idea is to give them skills to protect themselves against child abuse, and then also just general information about sexual abuse. And this can be contested because people feel like it's going to disturb, which I imagine it is, but it's disturbing to students or young children, talking to them, school-age children or preschool-age kids about sexual abuse. But research has shown that overall, there's significantly more positive outcomes when you're educating and talking about this issue with children than if you were to not. Okay, so I've talked about primary prevention programs. There's also something called secondary prevention programs, and that targets what we call an at-risk population or a specific group of people. And this can include single parents, young parents, parents with a psychiatric history, parents with a history of having been abused themselves, and low-income families. This is according to the chapter. So the goal is to just pinpoint people who need these services, and it's a little tricky to really decide who is the target, not the target audience, but the target group of people that need really tailored services. And it's tricky because child maltreatment is kind of hard to, I don't know, there's not a really clear definition of it, and it's not, generally there's parents that may be abusing their children and neglecting, but they're not, they're kind of lie on a continuum where they are also exhibiting positive parenting skills, and they're not bad parents through and through, but maybe they are abusing or neglecting their children, but they kind of lie on a continuum. So yeah, it's just a challenge deciding who exactly to target. And we spend more money on secondary preventions than primary prevention efforts. Some specific findings from programs. I can talk about one that started in 1980, actually the mid-'80s. It was called Hawaii Healthy Start Program. And they're paraprofessionals that would target families who were likely to abuse their newborn babies. And so they would have a paraprofessional meet with the mother weekly, starting during pregnancy and then up until the 3rd year of the child's life, and the visits would taper off as the child got older. That program was successful, and then kind of in the early mid-'90s there were more programs scattered across the country that were similar, where a paraprofessional goes into a home and provides services, support. But recently those home visitation programs have come under fire because they haven't been as effective as they were, I guess, over a decade ago, more than that. So they're not as successful now, and some people are believing that a paraprofessional might not be the most appropriate person to go into somebody's home, like there may be other things going on, like alcoholism or other psychological challenges going on in the home, and they just might not be well equipped for that. And then the chapter gave an example of a home visitation program that has been successful, and it's called Nurse Home Visitation Program, and instead of a paraprofessional, it's a nurse that meets with a mother who's at risk for child maltreatment in the second trimester of her pregnancy up until the 2nd year of the child's life. And that program has been really successful. So there's a little bit of a debate about who's the best equipped to go into somebody's home and provide them services. But what the author wanted the reader to take away from that discussion in the chapter is that you may not have figured out who the best person is or what the best way to provide in-home support is, but there have been positive results, so it can be successful. Moving on to talking about preventing child neglect. Neglect is the most often reported form of child maltreatment, but there's the least amount of programs we have for that area of child maltreatment, and basically the chapter is saying we need more research and more ways of preventing this, because it's kind of put on the back burner. It's kind of secondary to like programs that target physical abuse. So the story on that is we need more programs that work and more research about programs that are in place regarding child neglect prevention efforts. To conclude, the author suggests thinking about prevention efforts that are really more holistic, or looking at families more developmentally. In other words, providing different levels of supports for everyone. Thinking about instead of coming in after the fact and providing these intervention services, really thinking about how we can support everyone, because all parents need some level of support. Everybody would benefit from maybe counseling or more parenting classes, or some kind of support. So really thinking about a truly preventative approach, which we don't really have in place. It's more intervention. So do you have any questions about that, folks? Okay. Thank you for your time.
Thank you.